My guest at this time is Rob Henneke. He is the General Counsel and the Director of the Center for America's Future at the Texas Public Policy Foundation. What a lot of folks might not know is that Rob argued the case for the repeal of Obamacare due to the repeal of the individual mandate before U.S. District Court Judge Reed O'Connor. And on Friday, Judge O'Connor agreed with Rob and a group of 20 states and their attorneys general that, in fact, Obamacare should be repealed because of the end of the individual mandate, which was the main reason that Chief Justice John Roberts and a narrow 5-4 majority agreed to keep the law in place back in 2012. So Rob is here to talk about that and what happens next. Rob, congratulations. Thanks for your time today.
Well, thank you. Thank you for having me on. This is a great win, a historic outcome, and with the federal district judge ruling that all of the Affordable Care Act is invalid because of the unconstitutionality of the individual mandate. And, I want to pivot back to who I represent. I represent the individual plaintiffs in this case. My clients are individuals and families that have been the ones that have borne the brunt of this broken Affordable Care Act system, that they've lost the doctor of their choice. They've had their premiums skyrocket. They've been limited on their health care. They're the ones representing the millions of Americans that have lost insurance or continue to have poor outcomes from this. So, you have to separate the law from the policy because the federal district judge's ruling was very precise and tailored to the precedent and the text of the Affordable Care Act. But we also have to recognize the opportunity that we have to pivot now and to demand that our legislators and our policymakers in our states stand up and lead to get to better outcomes.
Talk about your clients a little bit more, because the vast majority, and I don't have to tell you this, of the media coverage we get on a decision like this, or even when the case is filed, is, well, here's all the people that are going to be hurt if it goes away. These are the people with pre-existing conditions because it's all lumped in. If the whole thing comes down, that comes down too, and so forth. There's millions more people who are covered than there were before this bill came, and those are the people that are going to be hurt. You're telling a much different story. What's the full picture as far as you can tell?
Well, thank you for that. I mean, when you look at it originally with the Affordable Care Act, what Congress did was it disrupted the health care of 20 million Americans to try to address an issue with approximately 1 million Americans. And when the left talks about people who may lose their health insurance, which I disagree with, but they're talking about Medicaid expansion. They're talking about Medicaid where the government added more people to who could be on basically health insurance for people at a certain level relative to the poverty line. There's millions of Americans that don't qualify for Medicaid and didn't qualify for subsidies, and are the men and women working, the small business owners, those that are self-employed, that have never been benefited by the subsidies and the handouts that were inherent in the Affordable Care Act. And one of my clients, Neil Hurley, is an example of that. He's self-employed. He has his own technology consulting company. And at the end of 2017, after his the law says he has to buy insurance through the Obamacare individual, the state exchanges, the federal exchanges, and he has complied with that law. And at the end of 2017, his premiums went up so much that he was not able to sustain that level of Affordable Care Act plan. And so the only options that he had for the plans that he was still able to afford made him have a choice between his doctors versus his children's doctors, because none of the plans covered both. And so, what he elected to do was to continue to have his kids cared for by their pediatrician, and him and his wife had to make the tough choice of dropping the doctors of their choice to go with an insurance plan that dictated which doctors they could see. And even as that's moved forward, the doctors under these Affordable Care Act plans are already starting to ration the health care. They're allowing only so many appointments per week for individuals that are under these plans. And so you look at it, even though he stepped down to a lower Affordable Care Act plan, Mr. Hurley still pays over $1,000 a month in premiums. He's got a $12,000 deductible. he's got to go out of pocket $24,000 in a year before his Obamacare insurance kicks in a single dollar, and all of this to be with a doctor that he wouldn't choose and with restrictions that come from it. And his story is personal to him and his family, but it's an example of the outcomes that millions of Americans have faced, and part of the reason why millions of Americans who purchased their own insurance have quit doing so, as they've literally been priced out of the market. So when we talk about people losing their health insurance, that's what's happening now, and that's what's been happening, and that's what the opportunity is now for our leadership to correct.
We're talking with Rob Henneke, who argued on behalf of everyday Americans in the case to repeal Obamacare based on the repeal of the individual mandate and the tax bill that came down about a year ago now. So walk us through, Rob, what happens next. I know some folks think this is the end of the line, but it's clearly not. Next, I assume it goes to the appellate level?
It will. So the federal district judge entered a judgment that all of the Affordable Care Act is invalid because the individual mandate is unconstitutional. But that judgment is not final until the case has been fully appealed, until the case has been fully litigated. So the immediate next step will be, number one, nothing changes today in terms of actual health care or the health system. The case will be appealed. California and the liberal state coalition that California has kind of been leading has already said they intend to appeal this case. And so the next step will be the Fifth Circuit Court of Appeals, which is the intermediate appellate court, that will be reviewing the trial court's order and making its own decision. I think that will play out through most of 2019. And I think it's highly likely this case will go back to the Supreme Court, where what will be interesting is that the Supreme Court will have to consider its own previous rulings, which correctly formed the basis for the outcome of this case this past Friday. And, I think if the court's going to be true and consistent to its own precedent, it'll have to agree that because of where things stand now, the Affordable Care Act is unconstitutional, and the ruling of the trial court last Friday was complete and correct.
And ultimately, I assume no matter what happens at the appellate level, it goes to the Supreme Court. Given the way John Roberts approached this issue 6 years ago, are you confident that even with a new complexion to the Supreme Court that ultimately you're going to get your way here? I
am. And I am because the whole basis for the court's ruling this past Friday was based on John Roberts' opinion in NFIB Sebelius. He found the Affordable Care Act constitutional because he said the individual mandate penalty was a tax, and it was a tax because it generated revenue for the federal government. Now that Congress has set the individual mandate penalty at zero, it doesn't generate revenue. It is Chief Justice Roberts' own analysis and own opinion which forms the basis of this case. And so I think the court will respect its own previous ruling. It will acknowledge that the facts have changed, but the law has not, and that ultimately the court will affirm the trial court's ruling. But we can't wait for that. We need to now pivot and see this as an opportunity for new action, that even while the case progresses through the court system, it's the time for the legislature to step up, for states to step up and start to implement policies. They're going to allow people to keep the doctor of their choice and keep an insurance plan that they can afford, and really deliver on the missed opportunities that we've had over the last 8 years of gridlock in Washington, D.C.
Well, it could tee up a major battle of philosophy between free marketers and the Medicare for all folks on the left. So we'll see which side has more passion and more specifics, if in fact that debate gets the chance to get started here in the coming weeks and months. Rob, one question that did arise from this, even by someone who liked the judge's decision here, is the power of a district court judge to essentially set the tone for an entire country. For a lot of folks on the right were frustrated that a district court judge out in Hawaii, for example, kept striking down different versions of the Trump travel ban. So what power should a district court judge have? What power do they actually have in situations that can affect the whole country?
Well, let's draw a distinction between when courts are, issuing rulings that further their own ideological viewpoint or seem to be driven towards a particular policy outcome, and versus what the role of the courts are. And the role of the courts, Article III judges, are to apply existing precedent, look at the text of the statute, and make a decision based on the facts. And that is precisely what Judge O'Connor did in this case, based on the ruling of the Supreme Court about the Affordable Care Act, and in making a decision on what was before him, as he was bound to do by the statute of the Affordable Care Act, even though the outcome of that is in declaring the Affordable Care Act invalid. We shouldn't look at the end result. We should look at the rationale for getting there, and where Judge O'Connor was very disciplined in tracking the language of the statute and what the Supreme Court has told him that he had to follow. That is completely different than other courts who are looking at the tweets of the president or the political outcomes of a particular decision, or other extrinsic variables in coming up with what it wants to do. So here, Judge O'Connor did what he had to do, as he was bound to do as an Article III judge, and that's completely different than when you see judges acting as super legislators and trying to rewrite statutes or try to cherry pick bits and pieces that they like or don't like, or otherwise trying to manipulate the law instead of just ruling on the law.
Very important clarification. Thank you so much for that, and we'll certainly be checking back in with you as the legal challenges unfold here. In the meantime, congratulations on the win, and thanks for your time very much today, Rob.
Thank you so much. Great to be with you.
Thank you, sir. Rob Henneke is General Counsel and Director of the Center for America's Future at the Texas Public Policy Foundation, and he also argued on behalf of many different individual Americans for the repeal of Obamacare before U.S. District Court Judge Reed O'Connor. I'm Greg Columbus reporting for Radio America.